Sometimes you have to see to believe. Sometimes you have to see to believe. Sometimes waiting isn't an option. When the news is breaking, watch with the newsroom of the Washington Post. We explain what's happening and why it matters. Thank you for choosing to watch the headlines as they're being written with our journalists. You can subscribe with a special offer, an entire year of the Washington Post for $29. Go to WashingtonPost.com/watch. Subscribing through that link lets everyone here, from the front lines to the control room, know that you care about our continued efforts to inform the public, protect the First Amendment, and foster a healthy democracy. We could not do this without you. Welcome to live coverage from the Washington Post. We have breaking news out of Minneapolis, Minnesota, where the jury has reached a verdict in the landmark trial of Derek Chauvin, the former police officer charged in the killing of George Floyd. This is a Washington Post special report. I'm Libby Casey. Well, the court has notified the media that the revealing of the verdict is imminent, and we will bring that to you live. We expect it to be announced within the hour. With me now, Eugene Scott, James Homan, and also Mary Beth Albright joining us to talk about the legal aspects of this case. Eugene, let's start with you. Of course, we don't know what the jury has decided, but give us the context of what is on the line this afternoon.
Well, what is on the line is whether or not what we saw on that video for 9 minutes involving Derek Chauvin and George Floyd will be viewed as something that is excessive and unacceptable and not permissible in policing, or if it will be justifiable, and if this will be something that law enforcement will be able to look at and decide that this is something we can put into place if we are afraid, if we feel threatened, if we feel distracted. And so what could happen going forward could have real implications, not just obviously in the Minneapolis Police Department, but what happens going forward in police departments across the country.
And James, you know, this is such a big story nationally, frankly, globally, but it's a very personal story for the family of George Floyd.
Yeah, and for the community of Minneapolis, Libby, this is something that this is their local police, and so many people have put so much on this trial, and for a lot of Americans, they're looking to it as a gauge of whether or not the justice system still works.
All right, James, so let's go through the charges here. There are 3 charges, and the jury could find Derek Chauvin guilty of any of them, all of them, or none of them. Let's talk through the most serious of these charges, James.
Yeah, so the most serious of these charges, Libby, is murder in the 2nd degree, and that requires showing that there was, it's basically, it's called felony murder. If you were injuring, assaulting someone, committing a felony assault, and someone then died, if you were intentionally committing that felony assault, even if you didn't intend to kill someone, that is 2nd degree murder. The less serious charge, still very serious, is 3rd degree murder, and that is a much lower standard relating to what intention is. And then the lowest of the 3 charges is manslaughter, which is that basically the suspect died in his custody because he showed a reckless disregard for his life. Ultimately, you know, if you're a court watcher, it's never a good sign when you have 3 pretty serious charges and thousands of pieces of evidence when the jury comes back, you know, within 24 hours. You know, the longer
not a good sign for whom, James?
For Derek Chauvin,
right.
For Officer Chauvin. You know, this is typically something where I think, you know, defense lawyers who were looking at it were saying, you know, you would want time to sow reasonable doubt and have, you know, people going through the evidence. Obviously, we don't know the verdict, and we don't want to speculate, but a quick verdict, relatively speaking, when you have these 3 very serious charges and so much evidence, is a really quite striking. And in fact, Minneapolis Public Schools were planning to do remote learning Wednesday, Thursday, Friday, and not today because the local school system didn't anticipate that they were going to reach a verdict today.
Mary Beth Albright, let's go to you for this process of the jury. So we got no word of jury notes. Oftentimes they can ask questions or try to get clarification from the judge. So talk to us about, you know, that process. And then, you know, Mary Beth, this has been such a waiting moment for all of us, eager to hear the verdict and the decision. But of course, the jury has been hard at work both last night and all day today.
Yes, Libby, when you think about the work that the jury had to do in this span of time, they have to pick a foreperson, they have to discuss the charges. It is a not a long period of time. I just from talking to people, it's less of a period of time than I think many people expected the jury to be out. And particularly, I think it's interesting that the jury didn't send any questions to the judge. Not good, not bad, just interesting. We don't know anything about where the jury's head is as one body. We don't know anything about what they're thinking. We don't know what their questions are. I mean, that's when the jury sends questions to the judge, it's a good indication of what they're thinking, what their questions are. But it's we haven't had any of that. And I think when I think back to the closing statements and the closing arguments, I think back to that chart that the prosecution put up of the 3 different charges and the grid of the different elements. And I wonder if the jury used that as some sort of a guideline.
Let's bring Keith Alexander into the conversation, our crime and courts reporter and our colleague who's been following this closely. So, Keith, these 2 charges of murder, 1 charge of manslaughter. How serious are these charges? What is the gravity that these jurors must consider?
Well, these jurors must consider the fact that they are considering putting a police officer in prison for pretty much doing an arrest. And that's something that a lot of jurors obviously struggle with. But if the evidence shows that this police officer went outside the bounds of the training and used excessive force, then that's what they're going to have to do. I mean, here's the thing. Chauvin is facing probably around, if he's convicted of second-degree murder, he doesn't have any prior convictions. So it's more than likely the judge will sentence him to the lower end of that sentence. So probably around between 10 to 15 years as opposed to 25 or more. If he gets manslaughter, same thing, probably more between 2 to 5 years as opposed to 10 years. So definitely looking at years in prison anywhere between 5 to 10 years, I would think.
Keith, this is remarkably quick, really, when you have to consider all of the things the jury was weighing and sort of the complexity of the instructions that we all listened to yesterday. Give us some perspective on, it's felt like a long day to many of us who were sort of anxiously awaiting any sort of movement or a jury note, let's say, but give us some perspective on the pace of this.
One of the things, covering these homicide trials, and I'm, you kind of get a sense of, okay, there'll probably be a day, 2 days, 3 days of deliberation. Now remember, the jury just began deliberations yesterday. They deliberated for about 4 hours. During that time, they had to, as was said, had to elect a foreperson, and they also had to wait till the evidence came in. And that to me was very interesting. I don't know what time. Usually it takes several hours for both sides, the defense and the prosecution, to bring all the evidence together that was admitted during trial, and then send it back to the jury room for the jurors to look over all of the physical evidence. And that to me was, for it to be done this quickly, it says to me, really, that the jurors, even before deliberations, had their minds made up. There was very little arguing, very little persuasion going on back and forth. These jurors knew what their verdict was going to be last week.
Let's go now to national reporter Hannah Jewell, who joins us from outside the courthouse in Minneapolis. Hannah, what is the scene like there?
Well, Libby, all day today, the streets of Minneapolis have been quiet except for the sound of plywood being put up on businesses and the sight of military vehicles of the National Guard rolling around. But that certainly changed the moment that we heard that a verdict had come in. I'm now in front of the courthouse where members of the public and the press are gathering. I spoke to two people just now, Tanya and Andre, 54 and 50 years old, who said that they wanted to be here. They thought that it was such a clear-cut case. They're 2 longtime Minneapolis residents who have been watching along. And they said that that they know that the problem of drugs is everywhere, and they said that half people they know are on drugs and they're all still alive, was what they told me. And they just kept stressing they think it's clear cut. But I asked them what would they do if the verdict went either way. They said whatever happens, they're going to both go home tonight. So I'll be out here in front of the courthouse. I'll be talking to other members of the public as we all await the verdict, the outcome of this historic trial. Libby?
All right, Hannah Jewell, thank you so much. James, we're hearing from the pool that Derek Chauvin is there now with his attorney. You know, we don't know what this man's fate is. And when we saw the jury being selected, we heard many of them sympathize with George Floyd, the victim. But we also heard some say, you know, I'm weighing that my decision could have real life implications for this other human being, Derek Chauvin. So let's talk about what his future could look like here.
Yeah, Libby, it's such a great point. And after the first part of the trial, as the prosecution was making their case, there were 2 chairs in the courtroom for the family members of George Floyd and for the family members of Derek Chauvin. And Chauvin actually had a member of his family who was there yesterday watching closing arguments. He is obviously a human being. We heard his defense lawyer, Eric Nelson, attempt to make that case. He's someone who spent 19 years on the police force. And for him, obviously, he's lost his job. He was fired immediately after this happened. Interestingly, even though they're pretty significantly different charges, murder 2 and murder 3 both carry that same recommended sentence for someone who has no prior convictions, which would be him. So the recommended sentence would be 10.5 years for murder 2 or 10.5 years for murder 3. And if it's manslaughter, then that's closer to 4 years. Typically, again, it's a recommendation. It's not a mandatory minimum. So this is serious jail time for someone who's been in law enforcement. And to your great point, Libby, one of the things that was so striking as I reflected on the prosecutor's closing argument yesterday was how out of their way they went to say that this was not the state of Minnesota versus the police. It was the state of Minnesota versus Derek Chauvin. And we heard from nearly a dozen Minneapolis police officers, including the chief who testified. And I think the reason they were doing that during the closing arguments was that also during that jury selection process, we heard some of the jurors express sympathy for police and law enforcement and what they do to keep people safe. So there was a real effort to separate this one officer, to frame him as sort of a bad apple versus the rest of the department.
You know, we heard yesterday the defense attorney, Eric Nelson, James, say, you have to take into account that officers are human beings. They can make mistakes in highly stressful situations. So we did, and he called George Floyd's death tragic. So we did sort of tiptoe into that territory of an admission that things went very wrong, right? But he really focused on intent, and Derek Chauvin trying to assess the circumstances, assess the threat risk, and make a decision. He used the word reasonable over and over. A reasonable officer, a reasonable decision. So the question is, did that resonate at all in jurors' minds or not?
Well, we know, Libby, is that the jurors were horrified by the graphic images that we all watched. They saw, photographs from the autopsy. We saw every possible angle from that, 9 minute and 29 seconds video. Obviously, Eric Nelson emphasized the 7 minutes leading up to Derek Chauvin putting his knee on George Floyd and explaining that totality of circumstance, all the reasons that he kind of might have been doing what he did. Obviously, Chauvin himself chose not to testify, using his constitutional right to do so, but he didn't give his version of events. Instead, his lawyer tried to raise reasonable doubt, and so I think the jurors, obviously, everyone horrified by that video, and that's why you heard Eric Nelson say it was terrible. But that's why the second degree murder is significant, because did he intend to commit an assault of George Floyd when he was kneeling on him, or did he think he was following his training?
And James, he doesn't have to have intended to kill him,
Exactly.
but intended to commit an assault.
Exactly.
Well, as James mentioned, one of the striking points of this trial was the number of police officers who testified for the prosecution. Let's watch.
Once the subject is handcuffed and no longer resisting?
Yes.
At that point, the restraint should stop.
Yeah.
A neck restraint is compressing one or both sides of the neck using an arm or leg, but what we train is using one arm or two arm to do a neck restraint.
And how does this differ?
I don't know what kind of improvised position that is. So that's not what we train.
If your knee is on a person's neck, that can kill him.
I absolutely agree that violates our policy.
Let's go to Eugene Scott for a reflection on that. Hearing from the police chief himself, Chief Arredondo, was especially significant, James. This was powerful testimony to see that blue wall crack, really, and not just crack, but to fully give evidence that they believed this was not appropriate behavior and was not part of the training and was not the values, frankly, of the department. How significant was that?
Quite, considering how historically when law enforcement officers have been on trial for violent acts, specifically against black people, many other law enforcement officers have come to their defense, trying to provide reasons to justify the behavior. But I think what we saw last year, in the weeks, months even, following the death of George Floyd, was protests from all corners of society, including many of those that have long been very supportive and sympathetic to law enforcement, that have challenged some police officers to be introspective and to say what we have is a real public relations problem with the people that we are meant to serve. And if we do not hear many of their complaints and concerns, we're going to continue to have this problem, and it's going to get worse in ways that we cannot control. And so let's step back and really assess what actually happened. And when you look at the facts, when you look at the videos, the multiple videos, it is clear that what Chauvin did was not consistent with the training of the Minneapolis Police Department. And you saw multiple veterans in that department not able to deny that and willing to go forward to say that this is not how we respond to the people that we've taken an oath to serve, and we don't want this to become the new normal.
Let's bring Rhonda Colvin into the conversation, who's been watching every day, every hour of this trial. Rhonda, what's on your mind now as we prepare to hear the jury read the verdict?
Well, just to follow up on those great points that Eugene just made, I think when history is written about this trial, it is going to be incredibly significant that all of these officers who worked with Chauvin, and especially those who trained him, Katie Blackwell, her clip right there is one that stands out to me in all of the things that we heard in the last few weeks. She said this move with the knee on the neck was improvised, that she, the training officer, did not recognize it, and it suggested that Derek Chauvin went rogue, essentially. He went against the protocol. And hearing the chorus that the state lined up of witnesses who could attest the training that they have and also the medical care that they're supposed to administer to a person who is in their care, that was incredibly stunning, and it was also a bit unprecedented. Now, about today's verdict that we're awaiting for, again, this is historical because over the weekend I was researching what are comparable cases that were similar to this one. And a lot of people have talked about the Rodney King incident that happened about 30 years ago this year. And that jury took about 7 days. And then I looked up the Philando Castile arrest and killing, and that jury took about 5 days as well. So it seems like the norm in these cases is often a week, but the fact that we are here less than 24 hours after both sides closed yesterday, it's really astonishing.
For those of you who are just joining us, we are watching the Hennepin County Courthouse, where momentarily the jury will announce its verdict, and the jury is deciding whether Derek Chauvin will be found guilty on any of the 3 charges he faces in killing George Floyd. The charges are second-degree unintentional murder, third-degree murder, and second-degree manslaughter. Let's go to Mary Beth Albright for some context on the differences between those. You know, Mary Beth, we thought we might get jury notes as they tried to sort of distinguish between these charges and the severity of them. As you mentioned, the prosecution put up like a flow chart yesterday, which really it's the judge's instructions that the jury must follow, but the prosecution gave this guide of if you find A and B and C and D, then Derek Chauvin is guilty. So let's talk about the process that could be going on behind the scenes with the jury, because there's so much we don't know. We don't know who the foreperson is. We don't know how they organize themselves. You know, what are you thinking about as you weigh their process?
Yeah, Libby, and don't underestimate the power of an organized flow chart when you're faced with 2 weeks of extremely emotional testimony. And this is not in any way to belittle any of the work of the jury. I'm just saying that when you're faced with mounds and mounds of testimony and weeks of your notes and weeks of 11 other jurors' notes, to be able to have something in front of you that's a chart that you can check off, that's organized by someone else, that actually coordinates with judges' instructions, I have found before is a very helpful tool for people. If you just think of it in terms of human nature, in terms of processing information, in terms of processing emotional information. So for example, I'm holding here in my hand, this is the complaint against Derek Chauvin. It's not very long, but it's just a lot of words written in prose, right? As opposed to the prosecution's chart that just had, here's the first element, here's the second element, here's the third element, and here's what you need to prove. And so the way, first degree murder versus second degree murder versus third degree murder, those are degrees of culpability that we in society have decided first degree murder is, for lack of a better term, the worst kind of murder, right? And that's why we're separating second degree murder is a murder that happens when you intend to assault someone. You don't intend to kill them, but you are intending to do bodily harm to them. And in the process, you wind up killing them. And so that's why that carries a higher charge, because we as a society have decided that that crime, that homicide carries a higher level of culpability, moral culpability. And we want that person to pay a higher debt to society than, say, murder in the third degree, which is, I'm looking for the term that the judge used, that it could that the person may not have intended it, but a reasonable person could have foreseen that their actions would have caused bodily harm. They didn't intend it, but a reasonable person could have foreseen that those actions would have. So to be able to see those differences, I think might have been helpful to a human being who's trying to process all this information. And then of course, the difference between murder and manslaughter is also a level of moral culpability in the law. So those differences may have been helpful to the jury.
Mary Beth, I do want to ask you about choosing a foreperson in that process. We'll talk about the jurors in more depth in a moment, but that's something that the jury has to figure out for themselves. And so that in itself may reveal a little bit about their process, right? Did they choose the woman who was a nurse, for example? Did they take someone who was older or younger? Who did they find to be their leader and their voice in this process?
Sure. And, is it the first person who steps up and says, I'll do it? Because sometimes you want that person, sometimes you don't, right? Sometimes you want the person who doesn't step up and say, I will be the leader, the foreperson. And so that's why, other people who have been commentating have said this, and I think it's true. That's why it's surprising that, as Rhonda noted, it's fewer than 24 hours since, we last heard from Judge Cahill and we have a verdict. And it's just, to be able to even choose a foreperson among 12 people in such an emotional case in such a short time, it's unusual, as Rhonda noted, given the history of cases like this.
Keith, let's talk about what happens next if Derek Chauvin is found guilty, because even yesterday, as court was winding down, after the jury had left, right, and that's important, after the jury had left, we heard the judge really blast a member of Congress for commenting on how protesters and demonstrators should be acting, or sort of weighing in on what she thought the jury should decide. And he indicated that it could be grounds for an appeal, frankly. And so there's a question of sort of what would happen next.
Sure, great question. Before I answer that real quick, I talked to some of my sources who've been following these type of cases. They said this case is unprecedented in terms of the number of police officers who testified against one of their own. So that will stay out in the history books. Unprecedented, the number of police officers who testified against one of their own. Now, to your question, Libby, yes. what's going to end up happening here is automatically in murder cases, in convictions, automatically there's going to be an appeal. That's going to be a given. So no one should be surprised when Chauvin's attorney files an appeal. What's going to be key, however, is will be the grounds for that appeal. Will it be the fact that a jury was picked right after a multi-million-dollar lawsuit was settled upon, or was it a fact that the Daunte Wright case happened during the trial, and then a press conference happened right outside the court, or even Representative Maxine Waters' comments that happened Saturday night before the jury was sequestered. There could be a multitude of reasons why the defense attorney will file an appeal, but you better believe an appeal will be filed no matter what, because that's just automatic. It's not going to be a surprise. It's just going to be when that appeal will be filed and on what grounds. Also, what's going to be interesting to see is if Chauvin is found guilty, if the judge orders him remanded immediately to jail. Sometimes judges will do that in a murder case, and sometimes they'll allow them days to turn themselves in. But it's interesting to see what happens with that if the judge orders him to be remanded immediately to prison.
Keith, safe to say that one thing we know is this is not a hung jury, right? So what is the significance of that?
The fact that everyone was on the same page, and it seems like almost immediately. Again, I think part of the issue is that they were sequestered. They spent one night last night alone, without their family and their friends. They were like, okay, we're not doing this again. We've got to. It came in today, and they were like, we've got to come together. We're not staying in this hotel away from our family and friends, and we've got to come to a decision quickly. And I think being sequestered, you can't underestimate that. That probably also played a role in this. That that they were just like, we've got to decide on a 4-person real quick, and we've got
Thank you. Please be seated. All rise for the jury. All right, please be seated. Members of the jury, I understand you have a verdict. Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, Count 1. Court File Number 27, CR 20-12646. We, the jury, in the above entitled matter as to Count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:44 p.m. Signed, juror foreperson, juror number 19. Same caption, verdict count 2. We, the jury, in the above entitled matter as to count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Signed by jury foreperson, juror number 19. Same caption, verdict count 3. We, the jury, in the above entitled matter as to count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:45 p.m. Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these are your true and correct verdicts. Please respond yes or no. Juror number 2, are these your true and correct verdicts?
Yes.
Juror number 9, are these your true and correct verdicts?
Yes.
Juror number 19, are these your true and correct verdicts?
Yes.
Juror number 27, are these your true and correct verdicts?
Yes.
Juror number 44, are these your true and correct verdicts?
Yes.
Juror number 52, are these your true and correct verdicts?
Yes.
Juror number 55, are these your true and correct verdicts?
Yes.
Juror number 79, are these your true and correct verdicts?
Yes.
Juror number 85, are these your true and correct verdicts?
Yes.
Juror number 89, are these your true and correct verdicts?
Yes.
Juror number 91, are these your true and correct verdicts?
Yes.
Juror number 92, are these your true and correct verdicts?
Yes.
Are these your verdicts, so say you one, so say you all?
Yes.
Members of the jury, I find that the verdicts as read reflect the will of the jury and will be filed accordingly. I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy-duty jury service. What I'm going to ask you to do now is to follow the deputy back into your usual room, and I will join you in a few minutes to answer questions and to advise you further. So, all rise for the jury. All right, be seated. With the guilty verdicts returned, we're going to have Blakely, you may file a written argument as to Blakely factors within 1 week. The court will issue findings on the Blakely factors, the factual findings, 1 week after that. We'll order a PSI immediately returnable in 4 weeks. And we will also have a briefing on, after you get the PSI, 6 weeks from now, and then 8 weeks from now we will have sentencing. We'll get you the exact dates in a scheduling order. Is there a motion on behalf of the state?
Your Honor, the state would move to have the court revoke the defendant's bail and remand him into custody pending sentencing.
Bail is revoked, bond is discharged, and the defendant is remanded to the custody of the Hennepin County Sheriff. Anything further?
All
right. Thank you. We're adjourned.